Hi friends, I welcome you once again to the lecture series Law Simplified, initiated by Just Law Academia. Today the topic of discussion is confession. This is a very prominent topic as far as Indian Evidence Act is concerned. The provision with regard to this topic has been incorporated under section 24 to section 30 of the Indian Evidence Act. See, it has not been defined anywhere. I would start my discussion just by quoting an example. I think with the help of that example, I would be able to clarify it in a better way to you. Suppose you have been charged with the commission of an offence of theft. Before initiating the trial, or when the police completes the final report, submitted it before the court of law, and you are to be charged. Now you go to the court of law and say, sir, I want to confess that I have committed this theft. Now, by merely saying so, the court will consider it as a gospel of truth and punish you, or the certain test which court has to fulfill before relying upon the confessional statement being made by you. See, section 24 says that if such a statement is made on account of a threat, inducement, or promise, then it will not be admissible. The only thing which court has to satisfy before relying upon the statement you are making, confessional statement you are making, is that it is voluntarily and it is truthful. If court considers that there is no threat, promise, or inducement as has been exercised, then this could be admissible and conviction could be based upon it. My dear friend, it is very, very serious affair, because you are going to suffer a statement which is ultimately going to harm you, and it is against your interest. So court, on this premise that nobody will suffer a statement against his interest, would allow it, will consider it relevant and admissible under the law. But still, court has to be very cautious. Now section 24 says this much only, that the statement, confessional statement, should not be influenced by these three factors. Fine? That is threat, inducement, and promise. Section 25 further say that if the statement is made to a police, that would be inadmissible. The reason I just state. Section 26, that if the statement is being made while in a police custody, that would again be inadmissible. See, there is a possibility of subjecting an accused or a victim with torture, high-headedness, beatings, and person might under a fear utter something which he never intended to utter otherwise. So if he has been influenced or his will has been dominated to such an extent that he is either nervous or fearful, then such a confession will never be held, volunteered one, and its veracity and truthfulness will always be in a question. So only in view of these facts that it has been held that if it is vitiated by section 24, or if it is made under section 25 and 26, then it would be inadmissible. Fine. Section 27 is again very prominent provision which requires a detailed discussion, but here for your knowledge I would say this much only: those persons who are in practice, they must be knowing that this provision is called a disclosure statement. Now, whether you are making a confessional statement or otherwise informing to the police about certain facts which is in your knowledge, and on account of these information or in pursuance of this information certain recovery is effected, then the part which led to recovery as per your statement would be admissible. Note the whole of the disclosure statement, only to the extent of the recovery part it would be relevant statement. Section 28 further says that if these three things, as we discussed earlier in section 24, that is threat, inducement and promise, if these are removed, then the statement would be considered to be the relevant and admissible. I think this should have been actually the proviso with the section 24, but anyhow it has occurred so we need to remember this way only. Now section 29 is again a very interesting provision, which is that the statement which was relevant as a confession but became irrelevant. Yes, section 29 further provides that if confession is otherwise relevant, it does not become irrelevant merely because it is given under the circumstances mentioned in section 29. So, what are those circumstances? It says that following 5 elements does not vitiate confession. What are those 5 elements? One is promise of secrecy. If the confession has been obtained by giving you an impression of promise of secrecy or exercising the deception, or in a state of, when you are in a state of drunkardness, then it has been obtained, or when you are being interrogated, or when on account of want of warning, like for because of these factors it will not held to be inadmissible, which is otherwise relevant. Fine. Section 30 talks about the confession by the co-accused. Now, can a confession by the co-accused held all the persons liable? The question is this. Now, the only condition here is that if the persons are being tried jointly, then the confession by one would be admissible against the other co-accused as well. Fine. So, my dear friend, this is with regard to section 24 to 30. The procedure has been led under section 164 CRPC to record the confession. Since I said in the beginning that is a very serious affair, court is required to be very cautious because somebody's life is likely to be in jeopardy because of his own self-harming statement. Then while recording the confession, the court has to give the warning to the concerned person that he is not bound to make such a statement, or if he makes a statement, this may be used against him, or that court has to ensure that he is making the statement voluntarily and he is not under threat or any kind of inducement or promise, as we discussed earlier. Then court has to, the very important thing is that append a note under section 164 subsection 4 of CRPC at the foot of the confession, where it has to be mentioned that the voluntariness was ensured and all the compliance were duly made, and then the confession was taken into account. So, my dear friends, this is how the confession statement is to be recorded. Now, confession could be of many, three, four type, like judicial confession, extrajudicial confession, and then the retracted confession. Now, what is the evidentiary value of these three? Like as I earlier said, that if the truthfulness and voluntariness of the confession is intact, then the conviction could be based solely on this confession. Fine. This again depends upon the facts and circumstances, material on record, circumstantial and surrounding circumstances, number of other factors which court has to ensure while convicting somebody on the basis of it. But still, if it is the intact, then the judicial confession, the confession which is being made in the court of law before a person who has been authorized by the law, fine, then it would be, the veracity of this would be taken as true, genuine, and conviction could be based. As far as extrajudicial confession is concerned, it is a confession which could be made elsewhere, not in the court of law, made elsewhere, before anybody, to anybody, and even to the self also, while offering prayer to Almighty also. Fine. So, it is certainly a weak piece of evidence. It cannot be acquitted with the judicial confession, which has been made after following the due process and procedure, I mean, laid down, but still whether the corroboration for this is required or not, again it is a question of fact. Now, it depends upon each and every case. Retracted confession is something that you made a confession in the beginning, and during trial you said that I was nervous, I could not, I mean, know it, the consequences of it, and it was not voluntarily made. I mean, number of excuses one can take, but now whether it is to be taken, I mean, into consideration, or will it be relevant or admissible enough, again court has to weigh the number of circumstances. The portion of retracted while making the confession once is retracted, but whatever statement he has made, now if to prove this statement there is other corroborative material available on record, then certainly the conviction could be based upon this. So, my dear friend, it is enough for today. What you need to understand is that confession means an admission of a guilt, one, not of a guilt of third person, guilt of your own. I mean, if you are incriminating yourself, you are not saying that Mr. A and Mr. B, I mean, they are the one who have done, then it will not amount to confession. So, it is what you need to remember. You must, I mean, it should be an inculpatory statement, you must incriminate yourself, and it should be with regard to the admission of the guilt, not admission of the fact only. The admission of fact will never be considered as a confession, only the admission of the guilt, acknowledgement of the guilt, yes, I have done it, fine. So, it should be very clear, precise, truthfulness, I mean, the voluntarily, and number of, I mean, the things which we discussed, like the court has to ultimately examine and base the conviction on the basis of it. So, I think I have been able to clarify it. Thank you very much for hearing patiently. See you in the next lecture. Bye bye.